Okay, so as already been mentioned, I'm going to shift the focus from the let's say relationship between the members of the couple to the relationship that still we do have between the two members of the couple and the child or the newborn or the desired newborn. So basically in my presentation, I decided to focus on let me just move this, okay, on two different parts. So in the first one, it is more theoretical. So I'm going to give a little bit an overview on which are the main rights and interests at stake, especially from the side of the child. And in part two, I will focus more on the intersection among Italian law, the Council of Europe, and the European Court of Human Rights case law with respect to this new ways of parenthood I'm going to discuss in the first part. So, as I told you, this first part will be more theoretical, and the reason I decided to start from this is because actually, as it is widely known, we are witnessing a time in history where biological parenthood is not the one and only response. We do have a variety of ways to conceive babies at the very moment, also thanks to technological innovations. So I'm not merely talking about adoption, as we will see. And therefore, there is this need to find ways to decide whether it is worth for the law and if it is in compliance with national constitutions, with international human rights law, to recognize legal bonds, even when they are not based on a biological grounds. Of course, I'm in favor of this, but this is like the very huge and, ratio and cruel question behind the overall presentation. So which are the causes of this debate? Which are the causes of and the reasons why there is this need and urge to discuss about the child best interest when coupled with these new forms of parenthood? Well, because as is it yet again widely known, infertility is unfortunately a disease that is very common. Also because women are increasingly used to having baby late in their career, in their life, so around 40s. I mean, Italy is not a very good example about it because we are very the average age is beyond 35 years old for the first kid. But anyway, infertility is one of the main cause. The other two causes are related to the possible death of one member of the couple, which could happen naturally in a couple that is married or in a cohabiting couple, or in cases of a couple, and this is more controversial, that is undertaking and a process of artificial procreation technologies. And here there is all the debate that we are going to say something about it later, about the so-called post-mortem insemination, meaning the feasibility and the legality, because for example in Italy it is not allowed to go on with the process even if one of the two members of the couple, especially the husband or the cohabiting male partner, so the one that it is not directly subjected to the treatment, is going to die within and during the process. Of course, the homosexuality of the couple or of the individual, and even the case of single parenting. So yet again, this is, let's say, the other side of the coin. So on the one hand, we have the causes of this new form of parenthood. The other side of the coin are the origins. So homosexuality is one cause of this new form of parenthood, regardless now of which are the options endorsed by each member states of the Council of Europe or of the European Union, or even Italy at the very least. But yet again, these are, I'm not going to read through all this, but these are mainly the origins, or let's say the situations in which we might actually talk about new form of parenthood that goes beyond the traditional form of parenthood based on marriage and biological bonds among the child and both members of the heterosexual couple. So if we move from the perspective of the status or the situation of the parents, plural, or parent in case of single parenting, and if we look at the child's perspective, it is interesting to say something about which are the rights at stake when we talk about new parenthood from the perspective of the best interest of the child. Because of course, and this is just a non-exhaustive list, of course, but just think about the case of a child born as a result of surrogacy of motherhood or as a result of ART process. And so here's when the right to know one's biological origin comes into play, because in a variety of legal systems, the law prohibits the disclosure of the identity of the donor. And this is a principle that is on which there is a wide consensus all over Europe. There is the first three are, I guess, more, let's say, we talked more about the first three, so personal identity, biological origins, and the right to family life, especially in case of non-existence of biological bonds with one or both members of the couple. Lastly, in the most recent case law of the European Court of Human Rights, as we will see in the second part of my presentation, there are interesting, there is an interesting insight on the urge to recognize the child's right to citizenship as a corollary of his or her legal identity. I'm referring to C versus Italy, for example, that was delivered this summer 2023. But even I'm referring to another interesting case that I will tell you something more about almost at the end of my presentation, that was held and delivered in November 2023 by the European Court of Human Rights, which ended up by recognizing a right to a birth certificate, which is, in my view, a groundbreaking judgment, but I'll get back to it. And of course, also the right to culture, religion, national origin, because of course, we have to kind of frame the analysis within a context where societies are not culturally or ethnically homogeneous. So these are also rights that should be taken into account when we talk about the child's rights. So another theoretical aspect that I think it is worth mentioning in this first part of my presentation is the fact that we cannot anymore focus our debate on a purely domestic level, because especially when we discuss new form of parenthood, well, one of the key features is the fact that we are witnessing an increase in recreative tourism, also because there are a variety of legal systems whose legislation regarding ARTs, but also adoption, and also at the end, surrogacy of motherhood, are widely diverse among one another. And so this goes hand in hand with the easy, depending on the economic resources of the members of the couple or of the single individual wishing to fulfill his or her desire to have a baby, there is an increase in cross-border movements. And this is one of the reasons that stands behind the clashes that we are witnessing in Italy, but not only in Italy, in terms of how to whether recognize, for example, birth certificate formed abroad. This was actually an issue that in Italy we had and we tackled also with regard to same-sex couples relationship, and that was solved let me just say this, just building a bridge with the previous presentation in the Orlandi and others versus Italy case, which was exactly about the possibility to allow the transcription of civil union, in that case, certificate within the Italian legal system. Right now, the debate within the Italian legal system is much more about whether or not, and the response, unfortunately, as for now, is more not than yes, to allow the recognition first and then the transcription of birth certificate of babies born abroad via surrogacy of motherhood. Especially, and even regardless of the fact that the state where this technology was performed was legal or illegal. So what matters is the fact that here in the Italian legal system, since surrogacy of motherhood is prohibited under criminal law, and this is another interesting aspect to highlight, there's no space, there's no room for recognizing this form of parenthood or relationship between the children born as a result of surrogacy and the intended parents. So there are some questions open to the debate before having a glance and have a look to what actually is going on in Italy and in the European Court of Human Rights case law. The first one is whether the best interest of the child, which we all know should be granted paramount resonance in the balance of the interest at stake, does always prevail when it comes down to non-biological parenthood. The second one is how to avoid difference in treatment among children, because of course, if a children is born as a result of ARTs and therefore does not benefit from biological bonds with both members of the couple, or whether a kid is born out as a result of surrogacy, and in these cases, only the link with the biological parent is recognized, we are facing actually a risk of increasing differences in treatment compared to children that do have a biological bond with both members of the couple, and that who can count on a legal relationship with both parents. Because here the issue is actually that most of the time it is not controversial whether or not to recognize, of course, the biological bond between the baby and the biological mother or father. What it is controversial, and the European Court of Human Rights has not gone so far to help us with that, is to ensure that even non-biological parenthood could actually fully recognized even within the context of the Council of Europe and the convention system. And lastly, which is the role of ethics and moral when this new form of parenthood comes into play? Because actually, as I will demonstrate in the second part of my presentation, the risk is to have morals and ethics to prevail over the best interest of the child. So let's move to part two, and let's see what's going on in Italy first in subsection A, and then in the case law of the European Court of Human Rights. So Italy is a very interesting, but even full of contradictions countries when it comes down to the regulation of, let's say, new form or alternative forms of parenthood. So in terms of the status quo, so what we have right now, of course, adoption is legal, even though it is subject to some limitation, as I will tell you in a second. ARTs is regulated by a law that came into force in 2004, so 20 years ago, a very controversial law. I will tell you something very briefly, even though there are so many things to say about this law, but this law has been amended several times by the Italian Constitutional Court, so to open up the possibility for Italian citizens to actually have true access to effective ARTs technologies. And in terms of surrogacy of motherhood, as I told you earlier, this is prohibited, again, under the same law that regulates ARTs technologies under criminal law. So if we kind of couple this three source of new parenting, meaning adoption, ARTs, surrogacy of motherhood, with the best interest of the child, meaning with the status of the child, actually we can see this parallel. So when it comes down to adoption, we see that we witness a sort of limited protection, at least until 2022, when the Constitutional Court of Italy delivered a very interesting case that I will tell you in a second. But you have to keep in mind that in Italy, single parent adoption is not allowed, with the exception of very peculiar circumstances, but generally is not allowed. Homosexuals cannot adopt. So there are a lot of limitations. Same is for ARTs and for surrogacy of motherhood. I didn't want to anticipate my following slide. So when it comes down to adoption, as I told you earlier, so no single parent adoption in Italy. There is nevertheless there has been this very groundbreaking, I would say, judgment of the Italian Constitutional Court number 79 of 2022 that allows a sort of second parent adoption in case of kid born as a result of ARTs technology performed abroad. And this actually is a big step forward, even because you have to keep in mind that when it comes down, for example, to the law that right now regulates same-sex unions, well, homosexuals, couples cannot adopt, and neither it is allowed second parent adoption, which was actually at the core of the debate when the law was in the midst of its approval, but then it was struck out. So right now we still have this imbalance and discrimination, of course, among heterosexual couple and homosexual couples when it comes down to adoption, as I told here in the slides at the third point. When it comes down instead to ARTs, let's say the scenario is much more complex, because Law 40 of 2004 was actually at the very beginning structured in a way to not really favor the access for heterosexual couples, married or cohabiting couple to ARTs technologies, because the law was actually, I usually use this phrase, a law of prohibitions. Of course, this is not, I have no time here to delve into the specifics of each of these prohibitions, but if you take a look at the slides, I try to summarize the key aspect, especially in light of the subsequent interventions of the Constitutional Court, which did a very good job actually in amending the law. So now we do not have any more limits in terms of homologous ARTs, meaning ARTs performed using both gametes of the members of the couple. So here there is no issues in terms of new parenthood, because the newborn possesses a biological link with both members of the couple. At the very beginning, the law prohibit gamete donation. Since 2014, instead, in Italy, it is allowed, even though you have to keep in mind that is not that much performed, because we do not have enough female gametes in Italy to perform gamete donation effectively when it is the woman that has a severe infertility or sterility problem. So here there is still a problem of tourism abroad, especially to Spain or to Greece, to perform gamete donation. So we cannot say that the problems are solved. And another intervention of the Constitutional Court that is worth mentioning here was held in 2015 with the possibility granted also to fertile couples to have access to ARTs, even when they are in cases of there might be a risk to transmit a genetic disease to the newborn, and therefore to have access to pre-implantation genetic diagnosis. Nevertheless, as I told you earlier, this law of prohibition continues to produce its effects because scientific research on human embryos is still prohibited. There is a ban to have access to ARTs opposed to same-sex couples, singles, couples beyond a fertile age. There is no definition on about what is the fertile age. Okay, so the legal wording is pretty vague in here. Yet again, postmortem insemination, as I told you earlier, is prohibited, and there is also a very controversial legal provision that exclude the possibility for the couple to withdraw the consent of the embryo transfer following the fertilization of the embryo, regardless of, I mean, if there is a risk for the health of the woman, the transfer won't be performed, but, you know, there might be a lot of other situations in which a couple or one of the two members of the couple might want to withdraw the consent, and this is not allowed under the law. Then the reality of what's going on in the clinics is slightly different, but I have no time to get into details. So in terms of surrogacy of motherhood, as I told you earlier, is criminally prohibited under Italian law. So I'm not going to I will move forward. Here, as I said earlier, these are a summary of the most interesting constitutional court's judgments related to each especially to ARTs and surrogacy of motherhood. You have to keep in mind that when it comes down to surrogacy of motherhood, it is not only the Constitutional Court that has a role to play. We had a recent judgment of the Court of Cassation, which actually condemns, as you can see here in the slide, surrogacy of motherhood, even if performed for altruistic motives, because surrogacy of motherhood continues to be perceived and as contrary to the public order. So here the best interest of the child, we can say, has no place. There were also some attempts by city councils to actually transcribe birth certificates of children born out as a result of surrogacy in the national registers, but some of them did that, some others did the other way around. But at the end of the day, the Court of Cassation confirmed, and this is a very recent judgment because it was delivered on January 3rd, 2024, the latter approach, stating that, yet again, since surrogacy violates women's rights and it is contrary to not only Italian law, but also the public order, these birth certificates cannot be transcribed. So there are, of course, a variety of criticism. I'm just going a little bit, I'm going to section B that has to do instead with the status quo of what is going on within the ECHR. These are going faster. These are simply a summary of, non-exhaustive, of the most significant case law delivered by the European Court of Human Rights on ARTs and surrogacy of motherhood. And these cases, especially those related to surrogacy of motherhood, so Menesson-Labassie versus France, first and foremost, but also the others that were delivered against Italy, meaning Paradiso and Campanelli versus Italy, that I will tell you something more about it in a second, are very emblematic of a different trend, in the sense that these cases shows, in my view, a trend of the European Court of Human Rights to recognize more firmly the best interest of the child. But you have to keep in mind that in these cases, the question was not about the conventionality, meaning the compliance of surrogacy of motherhood with the European Convention on Human Rights, but rather the question was which are the effects of this practice on the child's best interest in which are the way, whether or not it is in compliance with the European Convention on Human Rights to prohibit the recognition of the legal bonds of the child born as a result of surrogacy performed abroad within a state that conversely does not allow the surrogacy performed legally. So it was more related to the status of the child rather than on the conventionality of the best interest of the child. So maybe this slides is more interesting for you. So against Italy, we had two very interesting cases when it comes down to surrogacy of motherhood. The first one is Paradiso and Campanelli, which differs from the Labassi and Menesson case, because in here the question was about the legitimacy of the removal of a child from a family which was not first this child was born abroad as a result of surrogacy and was removed from the family of the intended parents. Then this kid was placed in a foster family and stayed with this family until he was 6. And then the debate was whether this child should or not be again removed from this family to go back to the family of the intended parents, meaning those who went abroad and performed surrogacy. And here, even though the first section actually found the violation of Article 8 and condemned Italy, the Grand Chamber reversed the judgment and found no violation of the European Convention, even though, yes, we do had this controversial removal of a child, which was 2 from a family. So here, whether this judgment is a very good example of how to safeguard the best interest of the child, and it's really doubtful. It is a more good example, let's say, the following case that it was delivered this summer, C versus Italy. It is a good example, yes, because here, regardless of the fact that the applicant, meaning the baby was born out as a result of surrogacy abroad, the European Court of Human Rights recognized the fact that the Italian authorities must recognize the legal bonds between the biological father and the baby. What it is more controversial, so this is the reason why this is not a very groundbreaking judgment, is that the European Court of Human Rights did not go too far to say, well, even the legal bonds among the intended mother and the kid should be recognized. So we can say that this judgment stands a little bit in the middle. So I'm not telling you anything about Protocol 16 and the margin of appreciation. I will just, since I'm going to, I don't have more time, I would like just to say 2 things at the very end. So in terms of the, if we have to say something about in a nutshell, about the case law of the European Court of Human Rights with respect to the best interest of the child when coupled with this new form of parenthood or intended parenthood, what I think it could be said to draw some conclusions is the fact that there is certainly a predominance in the recognition of the paramount relevance of the child's best interest when the question at the matters of stake is the recognition of existing biological bonds with 1 or 2 of the parents. But there are still a lot of resistance when it comes down to the full recognition of legal bonds when biological links are non-existent between the child and 1 or both unintended parents, because surrogacy of motherhood can also be performed when there is no biological links with both members of the couple. So sometimes we can even say that morals and ethics continues to play a role, that the lack of perceived consensus among the member states do play a role, that the margin of appreciation doctrine does play a lower role in, not pushing the European Court of Human Rights until now so far as to say, well, the best interest of the child should always prevail. And so I do not really, it should be granted more relevance rather than the fact that there's a lack of consensus among the member states of the Council of Europe as to how to regulate surrogacy or whether or not to recognize surrogacy as a legal practice within their respective legal system. And regardless all this, I think that a light of hope in terms of a possibility to invert the trend and to shape the European Court of Human Rights case law in a different way, so to ensure that the child's best interest does possess a true preeminence in the balance among the interests at stake, is this case, GTB versus Spain, that was delivered on 2023. The interesting point about this judgment, and then I'm going to stop, is not that much about the fact that here the court was discussing about a new form of parenthood, but that for the very first time there was a clear recognition of the fact that in order to safeguard fully the child's best interest, states must transcribe the birth certificate when the birth certificate is even when it was released abroad. So it would be interesting to see how this case will be actually used in cases involving birth certificate related to child born as a result of surrogacy performed abroad, meaning what will be the weight of this right to birth certificate grounded on Article 8 of the European Court of Convention on Human Rights in the future case law of the European Court of Human Rights. Thank you so much.